Hello and welcome to this Modern Criminal Law Review Plus panel on universal criminal jurisdiction. My name is Morten. I'm a doctoral researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg, Germany. It's my pleasure to serve as the moderator of this panel today. Our panel will reflect on the increased number of universal jurisdiction cases in domestic criminal courts and explore the many perspectives on the nexus of domestic and international criminal law. Nowadays, not a week goes by without news about another universal jurisdiction case being opened or another universal jurisdiction judgment being rendered. Just a few days ago, the Swiss Federal Criminal Court opened a trial against the former Gambian Minister of Interior, who is accused of crimes against humanity. In light of these developments, some already speak of a new era of universal jurisdiction. Despite its recent upsurge, however, many questions about the nature, legitimacy, and administration of universal criminal jurisdiction are not sufficiently answered yet. What justifies the assertion of universal criminal jurisdiction in the first place, vis-à-vis other states and vis-à-vis the accused individual? In exercising universal jurisdiction, what legal, procedural, and diplomatic factors should states take into account? Is justice from a distance even possible and desirable? As a result, universal criminal jurisdiction remains a highly controversial concept, especially in terms of its scope and the preconditions of its application. To provide a working definition, one could say that universal jurisdiction is the exercise of extraterritorial jurisdiction over certain crimes in the absence of any traditional jurisdictional link, such as territory or personality. One main reason for this definitional conundrum and the controversy surrounding the concept might be that universal jurisdiction finds itself at the multidimensional crossroads of multiple legal subdisciplines, so international and criminal law, different spheres, the international and the domestic, different legal domains, substantive and procedural law, and different rationales of attribution, collective versus individual responsibility. Today's panel is really a chance to address these questions, to start a conversation and to expand the ambit of our inquiry regarding universal jurisdiction. And I'm very delighted that three excellent scholars and true experts on this topic accepted to join the panel today, and that we managed to come here together as a group of speakers with different geographical and disciplinary backgrounds. Two of us arguably more being based in international law and the other two being more focused on criminal law. So let me introduce you to our panelists in order of appearance. First off, we have Professor Alejandro Chehtman, who is Dean and Professor of Law at the Law School of the University Torcuato di Tella, Argentina, and a Fellow at the Argentine National Research Council. He is an expert on ICL and jurisdiction, especially for states in Latin America. And today he will indeed talk about the legal expansion of universal jurisdiction in Latin America, especially in Argentina and Colombia, and will also discuss the value of universal jurisdiction even where no trials can be conducted for lack of access to the defendant. Then Professor Elies van Sliedregt, who is Professor of Criminal Law and Procedure at the University of Tilburg, the Netherlands. She heads the ERC-funded research project Joined Up Justice, which aims to develop parameters for a coordinated system of global justice at the domestic level. Today, she will discuss universal jurisdiction from a perspective of legal pluralism, noting that the domestic enforcement of international criminal law contributes to its heterogeneity. She will argue that pluralism is inherent in universal jurisdiction and not necessarily a problem. Then we have Professor Mari Takeuchi, who is a professor of international law at Kobe University, Japan, currently staying at the University of Oxford as a visiting professor. In her research, she focuses on the jurisdiction of states and the issue of extraterritoriality. And with a focus on the experiences of Asian countries, she will explore two blind spots of universal jurisdiction today in her presentation, specifically its underuse, so the inaction of states, and its potential overuse by infliction of capital punishment. I myself will share a few thoughts on the nexus between universal jurisdiction and domestic procedural law, focusing on a recent discussion in Germany, whether and how to improve the international outreach of domestic universal jurisdiction trials. Before we start, I have just a few housekeeping notes. We will have individual presentations by each of the panelists for around 10 minutes. After that, we will open up the discussion inside the panel, but also to the audience online. So to participate, please post your questions or comments in the YouTube chat, and you can already do this during the individual presentations. Okay. Without further ado, I would like to ask Alejandro to kick things off with his presentation titled The Paradoxes of Universal Jurisdiction in Latin America.
Thank you so much, Morten. I'm delighted to be here with colleagues I deeply admire, as yourself, Elies, and Mari. And also thanks to the Modern Criminal Law Review, which I think is a great addition to the international and transnational discussions on criminal and international law. So delighted to be here. So although I've been thinking about universal jurisdiction for a number of years, I thought that the best approach or the best theme for today's presentation was to give a comparative perspective given the rest of the panel. And in particular, talk about Latin America, which I think has an interesting story, particularly the Argentine and recently the Colombian case. So as most people will know, historically Latin America comes from decolonization and has had to traditionally fend off imperialistic drives, initially from Europe and its attempt to get some of its former colonies back, and then from the US and its important and influential Monroe Doctrine. So Latin America, on the one hand, has been keen on defending non-intervention and sovereign equality, as the Calvo and the Drago doctrines in Argentina show, or the Estrada doctrine against recognition of governments in Mexico shows, the key provisions on the Montevideo Convention, the work of Isidro Favela, and many other key Latin American jurists. So on the one hand, one would expect Latin America to be a region which is refractory or not particularly keen on universal jurisdiction. Now, at the same time, most of Latin America was suffered gross human rights violation particularly by state actors and more recently by non-state actors during the 1970s and 80s. And it has developed in a very innovative and vibrant way mechanisms for what we now call generally transitional justice, including an unparalleled, perhaps, emphasis in accountability elsewhere in the world. Which may start with a junta's trial in Argentina and comes all the way through Mexico, Chile, Uruguay, and other countries to a special jurisdiction for peace currently in Colombia. So Latin America is in the middle of these two experiences, which I think shape some of the reactions to or some of its approaches to universal jurisdiction. So over the last 20 years, many states, at least 12 states in Latin America, which is a majority of states in the region, have enacted provisions on universal jurisdiction in their domestic legal orders, mostly on behalf of conventional obligations and sometimes over crimes under customary international law, piracy, slave trade. These include Bolivia, Chile, Costa Rica, Cuba, Ecuador, El Salvador, Honduras, Mexico, I don't want to forget anyone, Nicaragua, Panama, Paraguay, and Venezuela. Notably, so two aspects which I think it's relevant to note. The first one is that several of these extensions or provisions on universal jurisdiction may be connected with the political influence of the United States, and in particular with its war on drugs or war on terror or its fight against corruption. So they have been a reaction to influences, continental influences by the US. And secondly, which I also think is interesting and goes well with the previous statement, most of these provisions have not been used by these countries. So as of 2020, there were only 5 investigations open in Latin America on the basis of this provision, 3 in Chile, 1 in Brazil, and 1 in Colombia. Now Colombia is a bit more active in this. So there were many provisions and virtually no activity. Now there's a clear outlier here, which is Argentina, which has not enacted any at least not recently, enacted any universal jurisdiction provision under its own domestic law. And nonetheless, it has more than 100 investigations open or initiated on the basis of universal jurisdiction, some with very high profile, including the investigation for the genocide or the alleged genocide in Myanmar, an investigation initiated against Chinese authorities for crimes against international law, an action brought against the Saudi prince Mohammed bin Salman for war crimes and crimes against humanity. And now there's debate about whether there's going to be an investigation open against the Hamas attack of October the 7th. So Argentina has been particularly active, and particularly active for a country that has not reached a congressional agreement on establishing universal jurisdiction. In fact, it's the 7th country with the more investigations initiated. All along, of course, European states, Canada, and Australia. South Africa, perhaps the following one in terms of the number of investigations open, has only 7. So Argentina is a very strange, interesting case, I think, for examining how this has worked. And it's interesting how this trend has come about in the country. So there was a criminal complaint by a private, an NGO and victims in the Argentine judiciary. That complaint was rejected by the first instance judge, the investigatory judge, and that decision was appealed. Now the appeals chamber, used the American Convention of Human Rights and the right to access to justice in Article 25 to order the first instance judge to open the investigation. And only later, Argentine judges realized that there's a provision, an obscure provision at the time, an obscure provision in the Argentine constitution establishing universal jurisdiction. And let me read this, that when a crime is committed outside the territory of the nation against public international law, interestingly, this is the kind of official translation, the actual wording of the clause is against the law of people. It says that the trial shall be held in such a place as Congress may determine by a special law, and this is a provision that was enacted in 1853 and was largely taken from the U.S. Constitution, Article 3, Paragraph 2, or via Article 117 of the Venezuelan Constitution of 1811. So this provision was not, no one paid specific attention to this, and it had become, of course, clearly influential. But it is important to note that this statement of universal jurisdiction was kind of a judicial innovation. And it was a judicial innovation based essentially on international law. Now, there's a subsequent issue which I think is also important. Argentina is a civil law country which has the principle or endorses the principle of mandatory prosecutions. And this means that in principle, judges must investigate all criminal complaints they receive. Now, of course, we know from the experience of Spain and Belgium during the 1990s that this can be particularly problematic, and particularly problematic for a country like Argentina with its peculiar history and geopolitical position. Now, again, I think the judges here were particularly clever, astute, inventive, and this happened when the criminal complaint presented by Human Rights Watch against Mohammed bin Salman took place in the middle of the G20 meeting in Buenos Aires. Now, the judge there established, again, with no legal backing, no explicit legal provision in the Argentine law, that that it had universal jurisdiction, that it could open an investigation, but he would not be able to proceed if the crimes were being investigated in other places. And so he asked Turkey, Yemen, and Saudi Arabia whether there were investigations there. And again, this worked pretty well in the sense that it, on the one hand, allowed him to say that he would open and he had universal jurisdiction over the crimes, but at the same time that he was not going to proceed until he could make sure that investigations were not taking place elsewhere. And this is one of the reasons over which Argentine courts are now trying to avoid investigating or opening an investigation against Chinese authorities. So I think both the opening and the restriction were the work of judges who were particularly innovative in this respect. Now, one immediate question one could raise is why Argentine judges were prone to do this, unlike most of the other judges in the region. I think this is a difficult question, and I'm going to offer some initial thoughts, which I think explain much of it, even if not all of it. So the first reason is PR, public relations. So Argentina has, over the last 20 years, conducted perhaps the most ambitious process of accountability for past human rights violations in the world, with many phases. So at some points, they opened investigation. During the 90s, they closed everything, and during the 2000s, they reopened them. And this has become a very sensitive and important political identity of the country. So it's good for judges to appear prosecuting crimes of the kind that were perpetrated by the last Argentine dictators. And one way to see it is that when the Supreme Court recently decided to set free a military person on a particular or peculiar interpretation of a rule on sentence calculation, this triggered very, very large demonstrations before the Argentine Supreme Court complaining against this decision, which was reversed in the following case. So PR, I think, is crucial, and judges need this kind of sort of public endorsement and public image before their constituency. Secondly, Argentina has been on the receiving end of universal jurisdiction against Astiz in France and Italy during the 1990s, which again was influential and helpful in the process of Argentina to reopen its investigations. And of course, it's seen the Pinochet effect, which is also indirectly relevant. So Argentine authorities don't necessarily see this as a problematic interference in the domestic affairs of the states, but rather as an opportunity for other states to initiate their own investigations triggered by these universal jurisdiction processes. The third element, which I think is also critical, is that Argentina, we allow for private prosecution. So NGOs and victims can be a parties and can appeal decisions. And in the first case against the Spanish officials for the Franco era crimes, the critical point that the prosecutor wanted nothing to do with the investigation, but it was the private prosecution and the parties and the victims and the NGOs which were able to get on appeal to the appeals court and get a favorable decision. And of course, this matters because they are the ones who have the most interest in Argentine authorities looking into this. And the fourth, I think, consideration is that it has not been particularly costly, politically costly, because of this adjustment the judicial authorities have done not to overstep what Argentina can do. So, in fact, political authorities in the Sixth Committee of the United Nations have been in favor when the International Law Commission was studying the issue of universal jurisdiction as states, would have been in favor of the legality of limited universal jurisdiction prosecutions. Let me close with why I think this matters, because the other peculiarity of Argentina is that it has not been able to conduct any investigation to the end. It has not been able to do any trials because it's unable. It has been unable to detain any defendant. So why is this relevant for Argentina? Why is this relevant for the world that Argentina uses this amount of resources in investigations that are not able to reach the trial stage, let alone, of course, the conviction stage? First, the communicative force these prosecutions have. The fact that there's an open investigation against a particular influential, important, critical individual is crucial for the cause of justice more generally, and it's often as much as universal jurisdiction cases can provide. But I don't think we need to underestimate the importance of this communicative force, this message. And secondly, and I think importantly as well, it's a forum for victims to tell their story and express their grievances before public authorities. And again, this is critical victims, as we have seen domestically, but we have also seen internationally. So on the basis of at least these two arguably limited but important points, I think this practice still makes a lot of sense. I'll leave it at that, and I'm happy to receive any questions. Thank you so much for the invitation again, and looking forward to the discussion.
Thank you so much for this presentation. I think it was a really fascinating geographical insight, and especially the idea that the historic experiences of a state shape its current stance on universal jurisdiction, I think is a really true idea. Next off, we have Professor Elies van Sliedregt with her talk, Universal Jurisdiction, Each to Their Own Jurisdiction.
Each to their own jurisdiction. I want to explore what was already announced by Morten, the inherent legal pluralism of international criminal law, which is only really multiplied because of exercising universal jurisdiction and domestic enforcement of international criminal law. So I think I'll start with quite a banal statement, because you hear it everywhere these days, and that is that the future of international criminal law is domestic. And that has everything to do, of course, with the principle of complementarity that underlies the International Criminal Court, and that assigns states, members of the International Criminal Court, to enforce their own statute through their domestic criminal justice system. This means, on the one hand, that there is increasingly legal dialogue and cross-fertilization between domestic courts and the ICC. It does also mean that domestic law enforcement is, as I already said, increasingly making it fragmented and pluralist, international criminal law, that is. Generally, if we look at the practice of domestic courts exercising universal jurisdiction, we see that they are aware of their role as international law enforcers. And this is to a lesser or greater degree. It impacts on how they apply the substantive norms. And we can roughly, I think, see two approaches. Some go full-on international, and that's what I'll call the internationalist approach. And that basically means that they will apply international statutory norms, mainly the ICC statute these days, the court being sort of the only one left in town, and the case law that is coming out of that institution, and they will see that as leading, and they will prioritize it even over domestic criminal law. And the reasoning behind this approach is, well, these are the norms of the international community. These norms have been violated, and therefore the whole set of the international legal framework should be relied upon, even if that deviates from time-honored domestic criminal law. Now, I have to add, this has not happened in many cases, and mainly in early cases. I think 10 years ago, Canada approached it this way, and I believe Sweden initially as well. The majority of states adopts another approach, and that's what I call the more moderate approach. And that's when international law is applied only with regard to the international crimes definitions, but with regards to domestic, the general part of criminal law, they will apply domestic foreign-specific law. So, for example, the internationalist approach, just to make the contrast a bit clearer, in that first approach, you will see courts applying international norms with regard to modes of liability, or with regard to the concept of intent, which indeed is at the ICC much higher than in many domestic jurisdictions. You have to prove that there was a purpose of facilitating the commission of a crime, whereas, for example, in the Netherlands, it's a much lower, it's a type of foresight test that you can apply, and I'll say a bit more about that later. But that really can make a difference, and it can be the difference between guilt or innocence. So two approaches, and let me just illustrate this a little bit more, this approach of domestic courts to international crimes cases, and then I'll come on to a universal jurisdiction. But first, by discussing the Van Angeland case. So you probably have heard of this case. It's an older one. I think it's 50 years ago by now. And Van Angeland was a Dutch businessman who was prosecuted on counts of complicity in genocide and complicity in war crimes in the Netherlands. And he had delivered the chemical TDG to the regime of Saddam Hussein, who then used that in weapons, poisonous weapons, which he employed and targeted the Kurds in Halabja. The district court that tried him acquitted Van Anraat of complicity in genocide, but convicted him for complicity in war crimes. The acquittal was based on the finding that Van Anraat had no positive knowledge of the main perpetrator's genocidal intent. This standard of positive knowledge was derived from the ad hoc tribunal's case law, where proof of knowledge of the principal's mens rea is required for a conviction of aiding and abetting. This positive knowledge standard differs from the lower Dutch standard of dolus eventualis, which employs a foresight test, as I just said. And the conviction for war crimes, funny enough, in the same case, there the court did base itself on national criminal law and just applied the dolus eventualis test. Why that difference? Well, the district court said that with regard to genocide, it was very much aware of the special nature of that crime, and in particular because of the specific genocidal intent, the intent to destroy in whole or in part a national, ethnical, racial, or religious group. The judges held that applying the Dutch standard of dolus eventualis would have watered down the intent to such an extent that it would not accord with the definition of the crime of genocide. On appeal, the judges endorsed the conviction for war crimes and the acquittal of Van Anraat of genocide. For different reasons, though, they basically said we can't prove that there actually was a genocide in Halabja, so the base crime has not been proved. Interestingly, with regard to applying the international knowledge test for complicity in genocide, the court said, and this is obiter dictum because for other reasons they acquitted him, but they felt they had to say something about how the district court applied this international knowledge test. They said that the standard should be in the Netherlands dealing with international crimes, that national standards in terms of intent, modes of liability, etc., should be applied by courts also when dealing with international crimes. And when you interpret criminal participation, complicity, you just rely on your ordinary criminal law, your general part. And this was, the court said, to prevent legal uncertainty. Thus, an opposite conclusion, really, from the district court. Moreover, and I find this interesting, the Court of Appeal found that, especially regarding the question of which degree of intention is required for a conviction for complicity in genocide, international criminal law is still in a stage of development. And it's not been crystallized yet. And as such, we're just going to rely on our domestic law, which we have evolved over centuries. There is a growing acceptance of this division of labor, where there should be an internationalist approach to crime definitions, but not for the general principles, modes of liability, intent, etc. Only there's one exception with regard to modes of liability for genuine international concepts like the command responsibility theory, which really has an international pedigree. Only for those types of concepts do we apply international law. We see that at least across a number of cases. So yeah, another case confirmed and endorsed this mixed approach. And this is the case of the Ethiopian Alemu. He was prosecuted for war crimes committed in Ethiopia in the late 1970s for his role in the so-called Red Terror purges. And Alemu was Dutch at the time of prosecution, but at the time of the offences he wasn't. In this case, the Dutch court also had universal jurisdiction. It's not clear whether they actually exercise universal jurisdiction or jurisdiction on the basis of the nationality principle. They don't specify this. But let's just assume this was a universal jurisdiction case. Here the court, again, it applied this mixed approach with regard to co-perpetration of war crimes, because that was the charge. It applied ordinary Dutch law. With regard to command responsibility, however, it applied international law. So it referred to case law of the ICTY and sort of imported that into the national system. Now, the question that arises, and this brings me basically to the next part of my presentation, Can you apply domestic law when you derive jurisdiction from an international title? Remember, Alemu was not a national at the time, like Van Anderaat. And to what extent is the principle of legality an obstacle to applying law of the foreign state against a person who was not a national at the time the offence was committed? Let me start with that first question, the question of legitimacy. What justifies courts applying and imposing a certain legal framework over another state's national? In literature, you can find a number of justifications. I list three of them. The first one I call the relationship theory. Legitimacy is derived from basically the court acting as representative of the international community. And as such, you do not make an incursion on sovereignty. You are serving the interests of the international community, so also with regard to the particular state whose national is on trial before your own courts. And here you could argue that with that comes sort of a prescription of the law that you apply. If you are indeed acting as a representative of the international community, you could say, well, then you have to apply international norms full on, everything. You adhere to international definitions and to the international norms regarding international liability. So the internationalist approach. The other approach I call the caretaker position, where a court fills a void left by another jurisdiction because they are the jurisdiction, for example, the collapse of the legal system. Think of Rwanda in 1994. Or the Netherlands here with regard to Alemu, basically enabling prosecution of crimes that could not have happened at that time. You could then argue such a court, a caretaker court, should apply foreign law. This is a bit like the forum choice in private international law, right? Where you see that they link that the forum that is foreign can apply the law of the state where the corporation is based when they choose to have the case decided by that foreign court. Interestingly, if you look at the ICTY, this has been a little bit the Yugoslav tribunal with regard to the former Yugoslavia. When they sentenced, they always would take on board local sentencing law in the former Yugoslavia. So there you have a little bit of that sort of, let's see how that was in terms of the standards, what the standards were locally. Let's take notice and try and apply that in the case in front of us. Third approach, which has been termed the reason dependence on standing theory, a bit of an odd term, but it's been proposed by Reeves in the European Journal of International Law already 10 years ago, I think now. But basically he argues the simple fact that a court has standing, the sheer ability of a court or a tribunal to respond to reasons for criminal liability, applying fair and adequate procedures, that already gives a court legitimacy. And this is why he calls it reason dependence of standing. It's about international criminal tribunals, but also domestic courts, that no specific jurisdictional claim needs to be shown other than that you are procedurally fair. And his approach would not come with a prescription to apply foreign or international law. It's just apply the legal framework of that court that is then basically providing for a fair trial. So as long as it comports to due process and fair trial rights, you're fine. Now, I have to say, looking at these three theories, and I'm very happy to be drawn on them, I think Reese's approach is the most compelling, simply because the others aren't really persuasive. I think the relational theory is problematic because we're all members of different communities in an increasingly global world. So which community are you actually representing? Also, the international community as such, I think, is quite an elusive concept. And in the same vein, I think we can disqualify the caretaker theory. Some, like Zigeti, even argue that thinking in terms of jurisdiction, territorial and extraterritorial terms is obsolete in the modern world. So maybe this is not the best position to take. So this leads me to conclude that on the legitimacy point, that domestic courts, when acting as international law enforcers, exercising universal jurisdiction, can apply domestic law when it comes to general principles of criminal responsibility. What about legality? There's some debate about this. So Lachazarianev, in a commentary on the Alemo case in the Journal of International Criminal Justice, writes that applying Dutch law to a person who was Ethiopian at the time of the offences violates the principle of legality. He pointed to the lack of accessibility and foreseeability. Now, I disagree with him. His critique of national courts, I disagree with him basically because it's based on the foreseeability argument. I think that really is a smokescreen. First of all, because much of the critique of expansive extraterritorial jurisdiction and threat to the principle of legality concerns crimes and not modes of liability. So very often this is regarding, definitions of crimes and not so much the general principles. We sort of take it for granted that there might be deviation there and we live with it. And in fact, it has been argued persuasively, in my view, that the foreseeability aspect of the legality principle does not play a huge role in international criminal law, at least not in the way that it does in domestic law. And this is because of the serious nature of the crimes. And this is often relied upon. It's also why the dual criminality verification has never been accepted as a limitation for the exercise of universal jurisdiction. Moreover, I don't think foreseeability is problematic because international law does not actually give much more legal certainty and foreseeability, as I just referenced the Court of Appeal in Van Anraat, where they said, well, you know, the fact that the law is not crystallized in the area is exactly the reason why we should apply domestic standards. I think until we have a widely accepted statutory framework on international criminal responsibility, we have to work with what we have, and that is a set of rules that in its core is well established and widely accepted around crime definitions, and forum-specific rules with regard to general principles of criminal law. So there you have it. Universal jurisdiction trials increase fragmentation, pluralism. They will often come with imposing norms that are foreign to the defendants that stand trial. Intellectually, this can be explained, justified, and accepted, I think. I just try to do that. The question that arises, though, so that's why it still sits somewhat uncomfortably with me, is to what extent do defendants have a right to equality before the law? Is the inherent pluralist nature of international criminal law and the reality of a patchwork criminal justice system sufficient to stave off this critique? I've not touched upon this, but I'm very happy to take questions during the Q&A or discuss this further with my co-panelists. So I'll leave it there. Thank you very much.
Thank you very much, Elies. A really fascinating argument you developed there. Next off, we have Professor Mari Takeuchi with her talk titled "Worthy of the Name: Challenges to the Ubiquity of Universal Jurisdiction."
Thank you very much for having me, and I'm so delighted to share the panel with great colleagues and friends. So following the previous two interventions, I'd like to draw attention to some blind spots of universal jurisdiction with a focus on Asian experience, which I hope makes a good comparison to the previous geographical two interventions. One blind spot is the underuse of universal jurisdiction. For instance, many Asian countries have not incorporated crimes against humanity into their domestic law, let alone subject them to universal jurisdiction. So let's say Asia contains 29 countries, and out of these 29 countries, only 2 countries, South Korea and the Philippines, both incorporate and establish universal jurisdiction over crime against humanity, which makes this region almost a legal vacuum in terms of universal jurisdiction of international crimes. And indeed, there are few cases of universal jurisdiction reported in Asia, but these are cases of piracy and terrorism. There is no case of universal jurisdiction over international core crimes reported so far. So let me underline here that Asia has already accommodated international or internationalized criminal prosecution, such as Tokyo Tribunal or extraordinary chambers in the courts of Cambodia, as well as domestic institutions for prosecuting international crimes, such as Bangladesh International Crimes Tribunal or ad hoc human rights courts in Indonesia. However, these institutions were tasked to address the past atrocities that occurred in the former Forum State territory, except for the Tokyo Tribunal, of course. So when it comes to prosecuting international crimes committed abroad, Asian countries remain relatively self-restrained. Another blind spot is its potential overuse. A considerable number of Asian countries have retained capital punishment and would potentially inflict it in the exercise of universal jurisdiction. For instance, Indonesia passed a new penal code in 2023, last year, in which genocide and crimes against humanity are made subject to universal jurisdiction and would incur the death penalty. International criminal lawyers have deplored the poor record of Asian countries' engagement in the exercise of universal jurisdiction. But is this development really what we are looking for? So these underused and overused universal jurisdiction in Asia may pose a challenge to the ubiquity of universal jurisdiction, but have remained relatively invisible in international law scholarship. To shed light on these blind spots, I think Morten's introductory piece provides a great starting point in drawing our attention to the multidimensional aspect of universal jurisdiction. In fact, international law scholarship, which I belong to, mainly focuses on whether universal jurisdiction has been established as rights under international law. That is the status of universal jurisdiction, to borrow the terminology of Morten's piece. However, not much attention is given to why there are such diverse approaches to universal jurisdiction, I think, which has been somehow explored by Alejandro's intervention, which ranging from complete inaction to full-fledged activation, or to what extent the diversity would be tolerated, moreover, or how universal jurisdiction should be exercised at the domestic level. And indeed, I fully agree that universal jurisdiction finds itself at a multidimensional crossroads. I myself would argue that in the context of asserting universal jurisdiction over international core crimes, criminalization mainly occurs at the international level, which involves a vertical order of jus puniendi vis-a-vis individuals, while the materialization of that criminalization as a form of universal jurisdiction takes place at the domestic level, which involves the internal policy consideration of a state, as well as the horizontal order between states. So put differently, I myself conceived the assertion of universal jurisdiction as an application of domestic law empowered and instructed by international criminalization. So by situating universal jurisdiction at the intersection of international and domestic law allows us to explore a little bit more about why Asian countries are hesitant to incorporate universal jurisdiction. One explanation is that the Asian countries' adherence to the principles of non-interference or sovereign equality. Indeed, commentators suggested that China's historical hostility towards extraterritorial jurisdiction stems from Western powers' past exercise of consular jurisdiction in Chinese territory and the unequal treaties which violated China's sovereignty and independence. A similar historical context might apply to Japan. However, since the beginning of the 21st century, Asian countries have increasingly been proactive in incorporating extraterritorial jurisdiction in the fields of antitrust law or data protection, to the extent that extraterritoriality has become almost the norm rather than an exception. Therefore, this explanation nowadays is becoming less plausible, although it can still be referred to as a rhetoric. So another account is the lack of pressing domestic need fed by Asian countries to establish universal jurisdiction over international crimes. Due to the Asian countries' strict immigration policy, it is less likely the case that both suspects and victims of international crimes are found in the same state. In fact, according to the UNHCR statistics, the number of asylum applications recognized in 2020 in the major economic powers in this region was quite low. In fact, India granted 1,360 asylum, which is still impressive, but China granted 53, South Korea 52, and Japan 47, which marks a massive contrast to that of Germany, which granted over 55,000 asylum in 2020, which topped the list for asylum recognition. This explained, if not justifies, why many Asian countries are reluctant to establish universal jurisdiction, whereas universal jurisdiction proceedings are predominantly happening in Western European countries. This scenario also allows us to argue that the inaction and the use of Asian countries does not undermine the legality of universal jurisdiction per se. In this regard, while Asian countries remain extremely reluctant to establish universal jurisdiction of international crimes, they have acknowledged that at least the core crimes subject to the International Criminal Court jurisdiction are crimes under international law, even when they are not state parties to the ICC statute. For instance, during the Sixth Committee's debate on the ILC's draft proposal for crimes against humanity, several Asian countries, including China, a notable critic of universal jurisdiction, admitted that the definition of crime against humanity under the ICC statute, which are mirrored in the draft article, would be acceptable. In other words, while reluctant to embrace universal jurisdiction in domestic law, Asian countries still contribute to clarifying the contours and contents of international crimes. I hope I have addressed why there is underuse of universal jurisdiction in Asia, but the underuse itself might not undermine the legality of universal jurisdiction. So let me now move on to the question of overuse, which is much trickier. As a realization of international criminalization, in theory, the exercise of universal jurisdiction should not go beyond the scope of criminalization. However, in reality, international criminal law is not as closed and crystallized as domestic criminalization, as the Elies intervention clarified. And in fact, it sometimes needs to be informed by domestic legislation and prosecution. So therefore, it does not always have a fixed boundary, especially when it comes to the scope of penalties. On the one hand, concerning international courts and tribunals, the trend in international criminalization has developed in the direction of precluding the death penalty. In fact, all the statutes of international criminal tribunals and courts established after the 1990s have excluded capital punishment from the range of penalties. But on the other hand, regarding domestic prosecution of international crimes, which are not necessarily limited to the exercise of universal jurisdiction, the death penalty has not been excluded. In fact, most recently in Asia, Bangladesh International Crimes Tribunal last year sentenced 4 individuals to death for crime against humanity. In addition, the authors of the ILC's draft Code of Crimes Against Peace and Security, adopted in 1996, did not specify a penalty for each crime, stating that, I quote, "Everything depends on the legal system adopted to try the persons who commit crimes against the peace and security of humanity." So therefore, the issue of the penalty remains open, and as it is up to the domestic court to consider to what extent the trend at the international level, which means the precluding the death penalty, should be weighed. So this is still the hypothetical scenario, but perhaps it would be argued that the infliction of the death penalty may not be precluded in the exercise of territorial jurisdiction. At the same time, insofar as the exercise of universal jurisdiction is concerned, there may be a room to argue that in light of the principle of legality enshrined in the constitution of the forum state, the infliction of the death penalty must be precluded because the defendant could not have foreseen it, because the international trend has clearly developing the direction of precluding the death penalty from the capital punishment from the penalty. So I stop here and looking forward to the question and answers. Thank you very much.
Thank you very much, Mari. Also, really interesting insight into the Asian perspective here. Well, now it's my turn. In my talk, I want to introduce the idea that there's a crucial nexus between universal jurisdiction and domestic procedure. So I will focus on the question of how domestic courts should administer universal jurisdiction and whether international law has any say in this respect. And let me use a well-known German universal jurisdiction trial as my starting point. The Al-Khatib trial in Koblenz was the first time state officials from the Syrian regime were convicted for its crimes under universal jurisdiction. And for the announcement of the verdict in 2022, the higher regional court provided consecutive translation into Arabic for the courtroom audience. And this was the first time this has been done in Germany. However, this linguistic inclusion at the end of the trial was kind of bittersweet, because during the trial, the lack of outreach efforts and language accessibility was one of the most voiced criticisms, because the court in Koblenz had denied journalists and the courtroom audience the right to listen to the Arabic translation, which was provided for the formal trial participants only. It argued that the court language is German and that a change in procedural norms does not follow from the special universal jurisdiction for international crimes. The Federal Constitutional Court, however, issued a preliminary injunction granting the journalists the right to use the court's translation system. It argued that the large amount of public attention and the special interest of Syrian journalists must be taken into account, and I quote, "All the more given that Germany is claiming jurisdiction under international criminal law, which it would not have under general principles governing jurisdiction, and which derives from the fact that the offenses in question affect the international community." End quote. And I think we have to recognize that there are two opposing conceptions of universal jurisdiction at play here. The argumentation of the court in Koblenz leads to an interpretation in which universal jurisdiction is the extension of national criminal law in the interests of the international community. German law is extended across the globe. It is then applied in German courts using German procedural law. And this view appears to be informed by a more classic state-centric understanding of international law. Jurisdiction, and more specifically penal power, are understood as an expression of state sovereignty. However, the Constitutional Court's injunction leads us to a different understanding. In that view, the principle of universal jurisdiction must be seen in light of a more community-centric understanding of international law, which entails that ICL is based on the jus poniendi of the international community. The administration of universal jurisdiction should therefore be understood as a derivative right. And consequently, and I believe, we have to conceptualize universal jurisdiction as a special form of vicarious jurisdiction on behalf of the international community. The idea that a state who's enforcing universal jurisdiction acts as a trustee for the international community is anything but new. Until now, however, it has not yet played an important role in our understanding of the administration of universal jurisdiction. In my view, the justification as to why it is legitimate for a state to adjudicate an extraterritorial international crime may also determine how the domestic court should carry out the administration of universal jurisdiction. Let me expand on that thought. If we just assume here that universal jurisdiction is a form of vicarious jurisdiction on behalf of the international community, I think its legal nature might then be conceptualized as four interlinked principles: representation, solidarity, subsidiarity, and transparency. The principle of representation entails that universal jurisdiction should be understood as a delegation of authority from the international to the domestic level. The domestic court acts as a representative of the international community, and in turn, the actions of the forum state indirectly establish the international community's capacity to act. So we can think of the enforcement of ICL and the administration of universal jurisdiction as being agent-dependent. That is because the specific censure of ICL for having violated the values and interests of the international community can only be adequately expressed by such an actor who is authorized and entitled to judge in that regard. Domestic courts and universal jurisdiction trials therefore have a dual role. They are partially endowed with an international legal status. Because universal jurisdiction is taken here as a special form of vicarious jurisdiction, the forum state may not act if there's a state more closely connected to the crime, capable and willing to adjudicate, or if an international criminal tribunal has taken over the proceedings. And this well-known idea of subsidiarity fits quite well into this vicarious jurisdiction framework. And it is not only an anti-collision mechanism, but also the foundation of an evolving multi-level international criminal justice system in which states cooperate and support each other in solidarity. And lastly, the principle of transparency. So what does it take to represent the international community? Applying international law on its own is not yet a sufficient expression of the idea of representation and vicarious actions, because many states follow and apply international law. So certain additional requirements must be met with regard to the transparency or openness of the representation. And those measures must ensure that the proclaimed universal jurisdiction is not only seen as the action of an individual state, but can be understood and respected in the world as the genuine enforcement of ICL on behalf of the international community. The underlying theoretical idea is that in case of vicarious action, the represented entity must always remain visible. Therefore, the importance of the accessibility and publicity of the proceedings should not be underestimated if one wants to ensure the long-term legitimacy of judgments rendered on the basis of universal jurisdiction. And any state who now wants to claim authority under universal jurisdiction must duly take these principles into consideration. And this results in a set of duties, which then informs the administration of universal jurisdiction. And the most basic, but also most specific one, I think, is the duty of legality. The forum state is bound to the normative framework of the international community. It may only apply substantive ICL as recognized under customary international law. In addition, the forum state is bound to all other norms of customary international law, notably international human rights law and its procedural guarantees. The second dimension is what I call the duty to properly administer universal jurisdiction, or in short, the duty of good governance. So there's no established international criminal procedural law at this time. Instead, it is an essential structural feature of universal jurisdiction that the domestic procedural law is mobilized to prosecute crimes against international law. And therefore, universal jurisdiction in principle grants a wide range of discretion to the forum state. And as Elies just presented, universal jurisdiction is inherently pluralistic in that sense. However, this discretion should be used to promote the interests of the international community. In addition, to be able to properly administer ICL, states must apply their respective procedural law holistically, in the sense of a functional equivalent to an international trial. In addition, the national justice system must be capable and funded in such a way as to guarantee a successful trial. And finally, considering the principles of subsidiarity and transparency, the forum state should also take the interests of other actors into account. And this leads us to the duty of loyalty. This duty follows from the special relationship of trust between the authorized state and the represented international community. It includes the positive duty to exercise the discretion with the interests of the international community in mind, a duty to optimize the administration of universal jurisdiction. This framework of principles and duties substantiates the principle of universal jurisdiction if taken as a special form of vicarious action as an instrument of collective, decentralized international law enforcement. Based on the consideration that the forum state attempts to speak on behalf of the international community and formulates the claim that its judgment is to be recognized as legitimate and final throughout the world, good arguments can be made for the accessibility and transparency of universal jurisdiction proceedings. The principle of universal jurisdiction in that sense internationalizes the relevant public. It internationalizes the domestic trial, at least to some degree. And furthermore, one must take into consideration that the public discourse on international crimes and trials is fiercely contested. And if a Western European state invokes the principle of universal jurisdiction to then administer justice in a foreign language without involving the affected society, the criticism of Western judicial imperialism can easily and to some extent justifiably be formulated. In addition, only an accessible and public judgment will effectively counteract denialism by documenting the crimes and acknowledging the suffering of the victims. So to come back to my case example from the beginning, the primary audience of universal jurisdiction trials is not the forum state's domestic population. The primary addressees of the judgment in Koblenz are not German citizens, but the victims, the perpetrators, the affected society in Syria, and the international community as such. Therefore, also the question in which language and in whose name justice is rendered seems very important to me. What's interesting to see now is that the German government currently plans to reform parts of the German Code on Crimes Against International Law, as well as the Procedural Code, with the aim to improve the broad impact, Breitenwirkung, or basically international outreach of universal jurisdiction trials in Germany. Unfortunately, the explanatory memorandum falls short of providing any explanation as to why, in contrast to domestic criminal trials, increased and extended publicity of universal jurisdiction proceedings is desirable and justified. However, I think it's really interesting to see that special procedural norms are introduced to cope with the unique features of universal jurisdiction proceedings. To conclude, my main idea or argument I wanted to introduce is that the principle of universal jurisdiction is maybe not just a mere technical formality that can be ticked off at the beginning of a trial and then forgotten. Rather, it may well be a normative principle that permeates these trials as a legitimating factor and which requires adapting domestic criminal procedure in universal jurisdiction trials to serve the interests of the international community. Thank you very much for your attention. And with that, we move on to the discussion and Q&A part of today's panel. So to the audience in the YouTube chat, you're now welcome to type your questions and comments into the chat, and also to the other panelists, you are please ask any questions, comments. I think what we heard, and it's really interesting in that we all have different perspectives, really much informed from our geographical or national background, but there are really common themes in what we presented. And I think it would be really good to find these common questions, these common problems, and try to maybe find an answer or come closer to an answer. So maybe to start off, I would like to ask Mari and Alejandro to maybe reflect on that Asia and South America kind of similar, and that you don't have that many universal jurisdiction trials going on. So what do you think are the differences between these two regions? What are maybe the similarities? And do we have any explanation maybe for that?
So yes, thank you very much for raising this great point. And I was actually curious about why South American countries are so not all the South American countries are keen on activating universal jurisdiction, although they incorporated universal jurisdiction at domestic level. But I think that the Asia and South America shared similar history, but and also that there are so many dictatorships in Asian countries, but for some reason, Asian countries are not very keen on activating or incorporating universal jurisdiction in the first place. Which, in my presentation, I think I said that the adherence to the principle of non-intervention or sovereign equality, it's not a plausible explanation for the reluctance of Asian countries, but still, as a rhetoric, it works quite well. It has been enshrined in the ASEAN's principles, and also the Asian countries are, and when it comes to the universal jurisdiction crimes, it's not only an extraterritorial matter. It's also a state crimes in which the state officials are involved, or state architecture is involved in promoting and committing the offense. Which that is why the Asian countries, with the sort of rhetorical adherence to the principle of non-interference, would not really keen on incorporating universal jurisdiction. But at the same time, as I said in my presentation, the more plausible explanation is that it's less likely in Asian countries that both suspects and victims are found, and which because of this is because Asian countries hasn't felt pressing need to establish universal jurisdiction. But then with this point, I definitely am curious about how Alejandro responds to why the South American countries are so keen, the Argentina are so keen on exercising universal jurisdiction, because it's without the presence of the suspects in the territory. Thank you.
Thank you, Morten and Mari. That's a great question, an interesting one. I don't know enough about Asia, although we've been talking with Mari for a long time, recurrently on these issues. I've learned a lot from her. So as Mari was suggesting, and she said in her presentation, I think the non-interference, non-intervention principle is very strong, and the fact that both regions come out of decolonization, though at different times, is a critical aspect of this. Now, there are certain dissimilarities which I think make the comparison more interesting and more striking. The first one is that in Latin America, you have at least one country that is keen, and Colombia is growing an interest in universal jurisdiction. And this is remarkable because unlike Asia, so the power in the world, the geopolitical power in the world is moving east, not to Latin America. So in Asia, you have very strong powers to an extent that you don't have in Latin America. I'm thinking, of course, China, India, Japan, South Korea, and you can go on and on. Whereas you don't have that kind of influence and kind of geopolitical weight in Latin America. So it makes it more striking that Asia has no interest in this, because it's comparatively less costly than for Latin American countries, particularly countries like Argentina or even Colombia, to prosecute these kind of high-profile cases. Now, one question I would have for Mari, and I think that this may make a difference, is whether inward justice has some explanatory power. So the fact that Argentina has prosecuted its own, Colombia is prosecuting its own, that gives them greater legitimacy. For some countries which have not done prosecutions for alleged international crimes in Asia, I think that would be politically much more costly. And it's interesting that in Latin America, two of the greater powers, Mexico and Brazil, who have not conducted inward justice, they're also quite keen on not going the road of universal jurisdiction. And the final question, which I think is interesting to think about, though I'll be very hesitant and careful, I'll try to phrase it as carefully as possible, is that Latin American legal systems, I think, are less concerned about international criticism in terms of procedure and substantive norms and penalties, as Mari very strongly put forward. So Latin American legal systems, and this touches a bit on what Elies was discussing, are much more westernized in terms of procedure, in terms of substantive law, in ways that are very, very, very deep. So in a sense, Argentina will never be particularly concerned, Argentine judges, not the state. The state is not, as I said, the key actor, I think, here, but rather justices are, or the administration is not the key actor. So I think they're not concerned about them being criticized on procedural, substantive, and penalties terms, as Mari was suggesting that some Asian countries, and we know some Asian countries would be. So I think this explains the striking contrast between the two regions, which I find.
Murray, do you want to respond in relation to like the national experience of prosecuting international crimes internally?
Yes, and it's a very briefly, as I said, then the Asian region is not sort of immune from the domestic prosecution of international crimes. For instance, I mentioned in my as I mentioned in my presentation that the Bangladesh International Crimes Tribunal or Indonesia has already also established a sort of human rights court, which is vested with the power to prosecute certain international crimes. But then it is very limited in time and the space. So it's not. So I think it's a slightly different from the experience of Latin American countries, and insofar as I can see, there's no mechanism that has been established to address the past dictatorship or past atrocity comprehensively. And so I think I need to dig more into that difference to the Asian experience and compared to the Latin American countries. But then I think this is a very interesting, striking difference between these two regions.
Thank you very much. I think another common theme we had in our discussion is like the principle of legality. And I also talked a bit about that. And what I did was like creating a normative framework if we take like an internationalist view and relational theory, and what does that mean, or would it mean for domestic law? And when I was thinking, what does the principle of legality entail in that regard, I came to the conclusion it can only be customary international law. So it cannot be the procedural law of the international criminal tribunals, because they have their own specific ones. So maybe you can create like baseline, but in the end, we need some common ground, and the only kind of solid ground I think there is like customary international law, and then in terms for criminal procedure, there's not so much there. So what I would like to ask, especially Murray and Elies, when you talk about the principle of legality, where do you put it, or where do you get it from? Is it like international? Is it domestic? How maybe those two interact? And especially, how does like this principle of legality then relate to the definition of the crimes, the modes of liability, but also maybe procedural law, and how do we navigate this legality sphere in the end?
That's a big question. So yeah, I mean, I think that the principle of legality, as I said in my presentation, it can be a bit of a smokescreen in the sense that the foreseeability argument is not always compelling, I think. These are very serious crimes. And we look at the substantive norm, as it were. These are such serious crimes, and there's always going to be some murder offense in some national jurisdiction that if you really want to sort of have a common denominator that you could refer to, as, you know, we all know that you're not supposed to kill people. So I'm not a big believer of that argument, or that objection, as it were. And that's also why I said, you know, with regard to certainly with the modes of liability and the intent, the general principles, I think it's much stronger to just rely on domestic norms. And I have to say, I do then look mainly at the European jurisdictions that I've been studying, and the Netherlands with this regard, where they're pretty clear, and where the law has evolved over centuries, and it is clear what intent means. And I don't think that's necessarily a problem that might deviate from the standard in the country that person has committed the crime. We'll just have to live with that deviation, I'm afraid. It's really on the crime definition, the international crime definitions, if you like, that we try to have norms there that are common across the board as much as possible. And yeah, they should then be incorporated in national jurisdiction. So I think it's also the member states with the ICC. I mean, generally complementarity means that you will have to incorporate these crimes in your own domestic law. So that should be sufficient. Can I just very briefly reflect on what you said, Morten, with regard to the where you can look at universal jurisdiction? I liked what you said about the Koblenz court. It's very much, it resonates very much also with approaches I see in the Netherlands. Funny enough, what we have, and I'd like to hear all of your views, if possible, with regard to prosecuting transnational crimes, that sometimes terrorism in particular, that now are used rather than war crimes because they're easier to prove, certainly when it's participation or preparing terrorism. We see in the Netherlands, France, a number of Western European countries where there's many UJ prosecutions, that rather than going for the international crimes, they go for terrorism. And then you deal with, in our case at least, courts that are not well versed in international law, because we have one particular court, a special court in The Hague, that does with the international, they do the international crimes. The judges, they know that they have to look at the international jurisprudence. But when it comes to a court in somewhere northern in the Netherlands, in Groningen, a district court, I mean, they have no clue what they're doing really, and they deal with terrorism charges. And there, how do you look at that? I mean, is there that same jus pudiendi of an international community? Ergo, does that come also with a duty to have a trial that has translations and everything? I was wondering what you would say to that, Morten, in particular, and because that distinction between international crimes and transnational crimes can be quite blurry, and we increasingly see that it is. So that's one thing, and the other thing, it just struck me. This is just more an observation. Our universal jurisdiction in the Netherlands is secondary in the sense that the perpetrator, has to be in the Netherlands before we can actually start investigating, right? And the whole idea behind our universal jurisdiction clause is we don't want victims living in our country to be confronted with perpetrators. And so I think our universal jurisdiction in that sense is very much an extension of territorial jurisdiction, actually. And that does not prohibit us to take this internationalist approach in procedural terms. We will still translate everything. As you know, you have access to our judgments in English, etc. So, yeah, I'm not so sure that distinction that you started out may work for Germany, but I don't think it works across the board in that sense. So, sorry, just blabbing. Hope you can respond to that in one way, or anyone in the audience.
Yeah, we'll try to start with the observation that there's like a conflation of like clear international crimes, transnational crimes, terrorist charges. We have the same problem or development in Germany as well. The thing is, it's like the same courts who are competent for both types of crimes. So we don't have like one specific court who is responsible for international crimes, but it's like the higher regional courts. So we have like some type of diversity there from the onset. I'm not sure whether it's a good thing. In the beginning, in 2002, there were discussions whether to introduce like one specialized court, but it didn't happen. So you often have German judges who come to these courts, and then for the first time, they hear about international criminal law, I feel like sometimes. It changed now because Germany, I don't know, has recognized that it's really a specialized field of law, and you have to teach your judges how to do that. In my presentation, when I talked about this framework, I really limit it in what I call, what many in the literature call universal jurisdiction, stricto sensu, or in the pure sense, international crimes, which I would then say does not work out for terrorist charges. So like this whole framework works only if the explicit jurisdictional grounding of the case is universal jurisdiction in that sense, and for Germany, which is then enshrined in Section 1 of the Code on Crimes Against International Law. in that matter, how like this jurisdictional clause is like framed. Yeah, in Germany, we don't have like this presence requirement as part of like the jurisdiction clause, but we have like the procedural limitation, where the prosecutor can decide whether to open or close a case along the presence requirement. So what we now have in Germany, that there are what they call structural investigations. So even if there's no known perpetrator, like an individual perpetrator, German officials will start to investigate the crime as like a complex situation in a way, without having necessarily the aim to have a trial in Germany, but it's more like an idea of having like a cooperative system where then evidence can be shared with other jurisdictions, with international tribunals. There, I would like to ask you, Elies, in the Netherlands, is like this presence requirement really so strictly enforced that the police forces cannot investigate in these cases? Okay.
Yeah, they look with envy to Germany, the prosecutors and the police.
Oh, interesting. I didn't know it. Yeah,
no,
yeah.
They really do. Yeah, they can't do anything.
Okay. Yeah. And then, like, I think we had in the beginning the principle of legality issue. So now I want to ask Mari to come back in.
Yeah, I think this is a really big question. So my answer is quite provisional. But then I think, as I said in my presentation, I conceive universal jurisdiction as an application of domestic law empowered and instructed by international criminal law. So I don't think that when assertion and application of domestic law in the exercise of universal jurisdiction, the domestic court cannot bypass the principle of legality enshrined in its constitutional law. But then I fully agree with Elies that the international criminal law mainly consists of customary international law, which is unwritten law. So there's always room to the judicial interpretation, which has been recognized by the European Court of Human Rights jurisprudence. So yes, it is still there is a core of the international crime, and somehow there's a fringe part of the international crime. So when it comes to the penalty, I think there is much room to be construed and constructed by the domestic courts. But still, for me, the principle of legality itself, very sort of a solid and solid principle enshrined in the constitutional law. But the international crimes, the scope of international crimes is not always that solid and fixed. That's my provisional answer.
Can I just very briefly jump in and then ask Alejandro if that's okay? Because we in the Netherlands, we have, this is with regard to international crimes, the requirement, our principle of legality is in the Constitution, and it requires, we've had cases around this and this has been clarified, it requires a Dutch criminal law provision. You can't directly apply international law, right? So you need it incorporated. In that sense, in criminal law is dualist. We're more monist with regard to all the other laws, but with criminal law, we're dualist. So how is that in Argentina?
In fact, I want to intervene on precisely that point. Let me answer that, and then let me add one small other point. So in Argentina, we have a similar provision, Article 18 or Section 18 of the Argentine Constitution talks about that no inhabitant and reading of the nation may be punished without previous trial based on a law enacted before the act that gives rights to the process. And that idea of ley is interpreted, has been interpreted only as a law of Congress. So what Argentine courts have done with the crimes committed in Argentina by the dictatorship, because they had to consider them international crimes to get rid of the amnesties and to get rid of the statutory limitations. So what they do is they qualify these crimes, or classify these crimes as international crimes for the purposes of non-applicability of statutes of limitations or amnesties, and then they prosecute them as domestic crimes, as murder, kidnapping, and the rest. So they use purely for conviction and sentencing purposes. They use purely domestic law. So in a sense, they are a slightly different model of the two models you mentioned at the very beginning, which I think it's interesting. And although we haven't had any convictions on universal jurisdiction, I'm sure the same will be done with any trial of that type. They would use the international court crime as a basis for universal jurisdiction, but then the investigation and the trial will be on the basis of domestic crimes. We don't have domestically crimes against humanity, war crimes, or genocide laws. So we use customary international rules for that, but then convict for domestic crimes. So I have one point on Morten's question about the criminal procedure, whether it's part of the limitations. I think it certainly is. It's not completely plural in the sense that you have certain minimum requirements on international human rights law that any state should comply with. So in a sense, it's not that dissimilar from the basic rules on core crimes or on the general part of the criminal law, in the sense that you have certain minimum requirements that any trial, in order to be accepted as legitimate and as fair, must comply with. I have many more points, but let me leave it at that for the moment.
Yeah, I completely agree, but it would be interesting to spell out what are the minimum requirements for those trials. I can now relay 2 questions from the chat to you, and you can maybe decide who wants to answer which one. And the first one is a bit maybe going to the point Alejandro made, that there's a value in universal jurisdiction investigations, even where there is no perpetrator present in the country. Namely, is there a possibility that different universal jurisdiction claims can clash, so that multiple states at the same time say, like, this is our case and we want it? So, and if there are there rules of international law for that type of conflict of laws or jurisdictional claims, and how should we resolve that issue in terms of universal jurisdiction? And the second one, we kind of spoke about that as well. It's like, is there inherent use of having like a code on international crimes in the domestic legal system? Who is addressed by these special codes? And in like these monistic and dualistic system, is there maybe actually purpose or value in bringing like the whole code on international crime as a whole together into the domestic system and not just like particular provisions? Yeah, please.
Shall I start very briefly? Yeah. Yeah, the positive jurisdiction conflicts, multiple states, I think is a very good question. And there's some thinking around this, and that there should indeed be a system of subsidiarity, that states sort of amongst themselves agree that they're, those with a territorial claim have a stronger claim of jurisdiction than universal jurisdiction, obviously. And I know that within the EU, they are trying now to figure out a system of interstate complementarity, almost, where they try to make sure that the state who's most, best equipped, as it were, and the most, the one with the strongest link, that they will prosecute these crimes. So there's definitely room for that. I would be in favor of that. But of course, we have many situations where states are very happy to, despite the fact they have a strong claim, not to do anything, and then others step in. And with regard to the, very briefly, one code or different provisions, I think the one thing, I don't think there's any strong, for me at least, strong preference for one or the other. It's just that it would be important, I find, to have, at least with regard to the general principles, that there aren't 2 systems within one domestic jurisdiction. So you've got complicity for war crimes as one concept, and complicity for theft as another concept. I think, to me at least, it makes sense to have one general part for all your crimes, and then you have the different specific crime definitions which come with, indeed, interaction and cross-fertilization with international law. So that's me.
Yeah, Alejandro?
Very briefly, about the question of conflict, it reminds me of a brief article written by Henry Kissinger against universal jurisdiction. He was saying, oh, we're going to have all these prosecutions, this is terrible. I won't comment on the particular thing. The reality is that is not and has not been, and it doesn't look like a very pressing political problem that we may have with universal jurisdiction. States usually take every opportunity they have not to exercise the universal jurisdiction problem. What I think we should think much more about is the geopolitical division of universal jurisdiction, where you have mostly European states prosecuting people from the global south. That is a problem. So we have to think about global south initiatives to take a bit more the reins of universal jurisdiction. And I think the Argentine model is not a model at all, but I think it's a good reaction, as the reactions we are seeing now from Africa at the International Court of Justice. The idea that the global south has a stronger role to play here, that's something that I think it's important to convey, and I think that is a political necessity in order to give the universal jurisdiction regime greater legitimacy, because otherwise its legitimacy gets undermined. So that's my concern more than the possibility of conflicts of jurisdiction, which I endorse everything Elies says, that it would be good to sort it out, but my main concern is separate. Thanks.
Absolutely. Mari, do you have anything to add? Otherwise, with the time.
Very briefly, I don't have any problem with the conflict, because in the context of criminal jurisdiction, it's only the forums. I mean, the custodial state in where the offenders are found has actually the power to prosecute and investigate. Not investigation, but then prosecute and try that the offender. So and so I have no problem with the conflict, but of course the application of the subsidiarity is needs to be more clarified, because what's the inability or the unwillingness, especially applied in the interstate context, is still still yet to be clarified. So that's my comment. Thank you.
Okay, perfect. Thank you so much for this really interesting discussion, and especially to those who participated in the audience as well. A few final announcements before we close the session. So to stay informed about upcoming MCLR Plus events, check the MCLR website and consider signing up for the mailing list. The next event will be a one-on-one conversation between Alison Liebling and Leo Seibert, both professors at the University of Cambridge, which will revolve around topics of prison life, suffering, and punishment. And we also have two special issue workshops coming up in the summer, one on rethinking criminal law and the other one on criminal law and literature. So please check out the homepage and register for the newsletter. And yeah, all that is left to say now for me is thank you all for joining. A special thanks to our panelists, Alejandro Chehtman, Elies von Sliedregt, and Mari Takeuchi, for your precious time. Thanks for participating. And last but not least, I would like to thank Professor Markus Duber, who's not only the mastermind behind the MCLR Plus project, but also our technician behind the scenes today. Yeah, thank you very much. Goodbye and see you soon.